So let's break down what just happened because this is getting really messy really fast. Blake Lively filed a letter motion basically telling the judge that she needs more time and that the judge should deny the pending motion because she said so. That's literally the tone of it. The motion she is trying to push off is Wayfair's motion for judgment on the pleadings. And that motion is huge because it basically tries to get rid of the bulk of her entire case. Now here's where it gets really interesting. Our favorite scorched earth attorney Kevin Fritz came back swinging with a response. And I gotta say it was impressive. He went straight for the core of her arguments and pretty much annihilated them. Obviously, we don't know how the judge is going to rule, but Kevin definitely laid out a solid foundation and made a direct plea to the court that looks hard to ignore. He starts with a really basic point. Any party is allowed to move for judgment on the pleadings after the pleadings are closed. That motion is specifically meant to challenge whether the plaintiff has even stated a claim. And here's the kicker: that right doesn't expire until trial is completely over. So technically, they can file this at almost any time. Blake's argument that Wayfair waited too long is flat wrong. She claims they sat on this for 9 months and that it's just going to waste resources. Kevin hit that head on. He points out that her second amended complaint, the operative pleading, was only filed 2 months ago, not 9 months ago. She wasn't required to amend her pleadings, but she chose to. She filed that complaint on July 30th, 2025. By doing that, she reset the whole process. Wayfair didn't even have to respond until weeks later. And once they did, only then were they entitled to move for judgment on the pleadings. In fact, Wayfair even told the court during a July hearing that they might seek relief under Rule 12C. Blake knew this was coming. If she's unprepared now, that's on her, not them. And then we get into the CRD issue. This one is brutal for her. Under federal law, to sue under Title VII, you need an EEOC right to sue notice. Blake's complaint doesn't have it. She didn't attach her CRD filing. She didn't state the dates, and she didn't show the judge that the parties she's suing are actually listed on the notice. That's basic stuff you have to do. Her first complaint back in December 2024 included, "It ends with us, without any right to sue attached." No CRD document. No federal notice. Nothing. She can't just patch that in later, without going back to court for permission. And she didn't. She added parties improperly from the start. Wayfair makes it clear you can't fix that mistake after the fact. So Kevin argues this motion should be granted because even if you give her every benefit of the doubt, her pleadings don't establish any plausible claim. And most of the issues are purely legal. For example, her California claims have no business in a New York court. Her retaliation claim is inadequately alleged. Her defamation claims are blocked by litigation privilege. And her conspiracy claim doesn't even have an underlying tort to support it. None of these require extra discovery. It's all right there in her complaint. And let's not forget she's already amended this thing 3 times. The court gave her chances. She still hasn't gotten it right. And even if she amended again, it wouldn't cure the problem that her California FIHA claims can't be brought in federal court in New York. She's in the wrong court, plain and simple. Wayfair also points out that granting this motion now would actually save time. It would cut down the number of claims early and streamline the rest of the case. That means less work later when summary judgment comes around. That's literally the point of a Rule 12C motion. And here's another big one. She's complaining that this will delay the March 2026 trial. But fact discovery is still going on. No summary judgments have even been filed yet. The trial is more than 5 months away. Kevin even cites examples where courts granted these motions way later in the process, sometimes after summary judgment motions had already been filed. So this timing argument just doesn't hold. And let's talk about her hypocrisy here. Remember how many motions she and her husband have filed? Sanctions motions, discovery motions, constant filings that force Wayfair to respond in the middle of discovery. She never cared about overwhelming the process then. But now suddenly she doesn't have time to respond? Kevin absolutely calls that out. Then we move to deadlines. This one floored me. She completely missed the deadline to serve requests for admission back on August 14th. That's one of the most basic steps to lock in facts before summary judgment. She didn't serve them, didn't ask for an extension, and now months later wants a judge to excuse it. Meanwhile, she's accused Wayfair over and over of being late. The hypocrisy is off the charts. Kevin flat out says she failed to show good cause. And honestly, it's wild that her high-powered attorneys even let this happen. Any litigator knows you can't skip the right to sue notice. You can't blow off deadlines. And yet here we are, And this goes back to the core issue. Blake never proved she had the right to sue in the first place. Wayfair doesn't even have to argue much. They just need to show the court that "it ends with us" wasn't in her original right to sue notice. Once you start a lawsuit on that notice, that's it. You can't go back and add new parties later without proper permission. And what's worse, her California notice even said that if she wanted to go federal, she had to file with the EOC within 30 days. Or 300 days from the last harassment incident. She didn't. By her own timeline, she was past the 300 days. That means she was time barred from day one. She knew it, and she still went forward. So Kevin tells the court that all of this chaos is Blake's own doing. She chose to file a second amended complaint. She knew Wayfair was going to respond. She knew deadlines. She knew about the OC requirements. And now she's crying foul because it all backfired. At the end of the day, Wayfair is asking the judge to cut this case down right now before it gets dragged further. And honestly, it makes sense. If the judge agrees, a big chunk of her claims are gone. The whole case shrinks. The court saves time. Everyone saves resources. Now, there's a hearing scheduled for tomorrow on this exact issue. Don't expect a ruling right away. The judge will probably take it under advisement. But this is a huge moment. If Wayfair wins, Blake's case is in serious trouble. But let's go a little deeper here and think about the broader implications. What we're seeing unfold is not just about one celebrity lawsuit, it's about how legal technicalities can completely derail even a high-profile plaintiff with endless resources. Blake Lively is a household name, with a legal team that charges astronomical fees, and yet she's facing the same hard deadlines and procedure requirements that every average plaintiff would face. That's what makes this fascinating. It's a reminder that in federal court, celebrity status doesn't give you immunity from the rules. Another big takeaway is the danger of over-amending. She chose to file multiple amended complaints, and every time she did, she opened new doors for the defense to attack her case. It's like hitting the reset button over and over. Wayfair sees that opportunity, and now they're aiming to wipe out nearly everything. And here's the PR angle. Imagine how this looks in the press. If the judge cuts down her case dramatically, the headlines will not be kind. Blake Lively lawsuit gutted is the kind of story that sticks. Public opinion matters when celebrities are involved, and the court of public opinion is often more brutal than the actual court. On the flip side, if she somehow survives this motion, it will be painted as a comeback moment. But survival isn't the same as victory. Even if some claims remain, the damage to credibility is already done. And don't forget, Wayfair has been consistent. They played the long game, letting her pile up missteps, and now they're cashing in. Kevin Fritz's reputation as a scorched earth litigator just got another boost. He's a guy who takes no prisoners. And that resonates not just in court, but in the media. So tomorrow's hearing is pivotal. No ruling right away, but the arguments themselves could tip the scales of perception. The judge's questions, the tone in the courtroom, even the way the attorneys carry themselves, all of that will be dissected. And we'll be here to break it down for you as it unfolds. So tell me in the comments what you think. Is this the end game for Blake's lawsuit? Or does she still have a chance to salvage something? Don't forget to give this video a thumbs up, subscribe if you haven't already, and click the bell so you don't miss my breakdown after the hearing. Thanks for watching.